Hello, this is Matt on the Moon Lambo channel. Look at this headline from the Crypto Basic. Deaton excited as Paradigm files amicus brief supporting Ripple against SEC. Now, this is the 16th amicus brief that's been filed by a firm called Paradigm. And having read through the whole thing just this afternoon, I personally find it to be the most persuasive amicus brief that's been filed in terms of application in law. And there's a reason that Attorney Deaton and myself both got excited, and many others did as well. It's like the degree to which they slaughter the SEC on a fact basis is astonishing. My friends, get this, and I'll show you in a second, but they included, I think it was a 181 page research paper. And I believe, and I haven't read that whole thing, I just read the amicus brief, but it's a 181 page paper, research paper, and it goes in depth into, as I understand it, every bit of case law that's ever existed having to do with Howey, and showing how what the SEC is arguing does not fit in any of that. There is no legal precedent whatsoever for what the SEC is arguing, and it's just devastating from a pure logic point of view. So I am really curious to see what the judge has to say about that. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Shout out and credit to James K. Filan, who of course is an attorney within the XRP community, who shared this. And I'm going to start by showing you what Attorney John Deaton had to say in response to this amicus brief dropping from Paradigm. He said, "Very happy right now that, who's this tag? Lewis Cohen. Very happy right now that Lewis Cohen's, and then this is the title of the paper, The Ineluctable Modality of Securities Law, Why Fungible Crypto Assets Are Not Securities, is an exhibit to the brief. Great news on a rough day." And here, I'll just show you, like, this is an exhibit as part of the amicus brief, which is why in total, this whole thing, if you look at the top, you can see here, 206 pages. So this is the part that I didn't read through. It's not crypto specific. I mean, it's about why crypto, yes, of course, crypto assets are not securities. But what I'm saying is it takes a deep dive into like case law, as I understand. So again, this is it. You can just scroll through. I mean, this thing is a freaking beast. I have no intention of reading this specifically. That would be a bit too much. You know, keeping up with just the 16 amicus briefs has been ridiculous with my schedule. But, you know, I've done pretty well, all things considered. But my gosh, look at this. It is thorough as can be. And so what I did is I went ahead and highlighted the parts that I found to be most interesting here. And I made some notes along the way. But you're going to absolutely love this. And you'll see why it's so destructive. It just wrecks the SEC's plans. This exhibit even alone wrecks the SEC's plan. But then thankfully there's also an amicus brief that goes through it. Oh, and actually I wanted to mention this too. I came across this tweet from somebody by the name Dibspot responding to Attorney Filan here. And I thought this was a pretty good response to what the brief included. And Dibspot wrote, "I love how this brief includes an entire research paper on the securities laws, basically doing the judge's homework for her. Excellent. It makes a fair point on the per se argument. Libraries should take note of this informed brief and appeal their rule." And so when he says per se, talking about the, is a cryptocurrency by the nature of existing a security? You know, is it per se a crypto? But yeah, basically, the homework assignment was done, fully completed, and handed over to the judge. Here you go, Judge Torres. No additional work required, just read this thing. So let's scroll down now. So I got to get down to page number 1, if you're looking at the page numbers on the bottom anyway. Yeah, here we go. So, interest of amicus curiae. Paradigm is an investment firm that backs innovative crypto/Web3 companies and protocols. To help these projects achieve their full potential, Paradigm offers them a range of services from the technical to the operational. So that's in a nutshell who they are, what they do. And here's a summary of their argument, and this is truly powerful. Take a look at this. A subtle distinction of monumental importance lurks beneath the surface of this case and threatens to displace Congress's role in deciding how crypto assets will be regulated. On the surface, this case is about whether certain offers and sales of XRP tokens were securities offerings. And I'll pause to note here, You know, as it turns out, and I realized to the degree that this is important just the other day, and I never pretend to know everything. Obviously, we understood the sales were an important aspect of this, but even if there were no sales, if there's just what could be perceived as an offering, apparently that could be a problem. So even had Ripple sold nothing just by holding XRP, that could have been a problem. And that's effectively what the judge found in the SEC v. Library case, by the way. And that's why they wrote in italics offers as well as sales in italics, because they understand the distinction. And then the brief continues. But the SEC's rhetoric goes further than its claims require or the law supports. It asserts that XRP tokens, and by extension many other crypto assets, are themselves securities. The SEC's apparent attempt to conflate an investment scheme with the crypto assets sold in that scheme is unsupported by legal precedent and fundamentally inconsistent with existing securities laws. To this end, a comprehensive study conducted by one of the firms on this brief reviewed every single relevant federal appellate case to have applied the Howey test. Pause. That is insane. And this is why we have what is effectively an intense 181-page research paper attached as an exhibit. Again, they right here reviewed every single relevant federal appellate case to have applied the Howey test. And it's just like, here you go, Judge. Here's the homework. It's complete. My gosh. Brief continues. This study confirmed that no federal appellate court has held that an asset that is the object of an investment contract transaction is itself a security, nor that a subsequent transfer of that asset would be a securities transaction, nor has the SEC cited any such authority. Next page. The distinction between offer and sale transactions and the underlying crypto assets is critical. The SEC regulates a variety of fundraising schemes, and courts have evaluated those schemes for decades using the test set forth in SEC v. W.J. Howey Co. That is not new, but the SEC's effort to graft that same Howey analysis onto XRP tokens themselves is radically new, and it is the foundation upon which the SEC seeks to claim sweeping new authority to regulate not just investment offerings, its proper statutory role, but virtually the entire secondary market for crypto assets. And I read that and I paused, just like, amen, brother. Exactly. That's exactly what it is. And this is completely in line with what Ripple has been arguing to this point anyway. You know, it's just as a matter of law. And that's why Ripple's motion for summary judgment should be granted, and I hope that it's granted. Anyway, the amicus brief continues, though. The SEC's objective may be understandable, but its approach is not founded in existing law. A comprehensive analysis of federal appellate law reveals that no authority exists to support the SEC's attempt to transmute the Howey analysis of an investment contract transaction into a conclusion about the underlying asset. So pause, what they're saying there is the Howey analysis is intended to analyze the scheme of whatever is being discussed, whatever the discussion at hand is, whatever the case may be, but it's not to be applied for the underlying asset. It never has been. Brief continues. In every application of Howey where an investment contract was found, there was some identifiable legal relationship, that's written in italics for a reason, legal relationship between an ostensible issuer and the investor providing investment capital. Put another way, the SEC's effort to construe XRP tokens as securities, even though XRP tokens create no legal relationship between the owner and Ripple Labs or any person or entity, invents a new form of issuer-independent security untethered from the powers conferred by Congress. So pause, what they're saying there by issuer-independent security, it's a security, it's a new form of security. This new form of security exists even without an issuer. Completely untethered from the powers conferred by Congress. The SEC is just asserting it is. It's a new thing, and it is. Congress be damned, it just is. That's exactly what they're doing here. This is why I do find this exciting. I do find, because the judge is going to see this, and it's, if you're unbiased, this is a slam dunk. You know that this is correct. If you're unbiased, clear as day. And I admit I'm biased, but still, I firmly believe what I'm stating here. Brief continues. For instance, Ripple Labs could go bankrupt and emerge with new legal entities without impacting the owners of XRP tokens. This is unlike any other type of security known to our securities laws and instead resembles a commodity. Well, how about that? Because with a commodity, can you imagine like oil or corn or soybeans? Like if there's a major entity that's, really helping to get those soybeans to you, and then they go belly up, another entity could come in and just become gigantic and get you those soybeans. That's exciting, isn't it? Everybody loves some soybeans. Okay, well, doesn't that sound like a commodity? Yeah, same with XRP. I'm not saying XRP should be defined as a commodity. Just call it anything but a security. I'm even open to that discussion. That's fine. But just declare it's not a security right now. That's what I'm saying. And so they're hitting the nail on the head here. This is markedly different than anything else that's been analyzed under Howey to this point. I mean, other than, there's Telegram and Library and Kik, but we're going to get to that. Anyway, brief continues. The SEC's attempt to obtain new authority through the courts is regulatory overreach. The SEC believes that someone should regulate crypto assets, and by branding the assets themselves securities, it is attempting to bypass Congress and bring crypto asset markets under its authority. That is precisely what the Supreme Court cautioned against last term in West Virginia v. EPA. And I talked about that story. I'm not going to explain it in this video. But it is not the proper place for the SEC nor the courts to usurp the role of Congress and choose a regulator for crypto assets by straining Howey to conflate fundraising transactions with the underlying assets outside the bounds of appellate authority. Nor is it necessary to do so to resolve the claims before this court. So let's pause. Now, this next part might make you get a little bit concerned. I'm still on board with what Paradigm's broadly arguing here. And actually, like, about 100%, but some of the stuff in this, with this next topic that I read throughout this brief, maybe go, you'll see. Just check this out. Whatever decision the court makes with respect to defendants' offers and sales of XRP tokens, it should decline to pass judgment on the status of XRP tokens themselves. When facing matters of this significance, outside the bounds of any appellate precedent or statutory guidance, and with the regulation of an entire market at stake, the power rests with Congress. Okay, and you know what? Fair enough, technically. And they are arguing that tokens themselves are not a security. So that means Paradigm is arguing that XRP is not a security because it's a cryptocurrency. So Paradigm is arguing it's not a security. But when they say that the judge should decline to pass judgment on the status of XRP tokens themselves, as long as it's literally taken like that, I suppose that's okay. But here's what I'm saying. I'm not calling for the judge to declare what XRP is, but I am saying the judge should say what XRP is not, which is different, because XRP is not a security. It's okay for the judge to say, just as Paradigm is in this piece, XRP is not a security. In Congress, hey, if that's accurate, it's in their hands, cool. Let it get figured out, fine. It shouldn't be for the SEC to determine, fine. But you can clearly see that it is not a security. And so if that's the case, I think that even just that ruling from the judge, should we get it, would result in very good news for XRP holders, as I think it would ultimately be relisted on exchanges the world over, and Ripple could resume what they're doing, presumably, with their business as it pertains to on-demand liquidity, and everybody would be doing their happy dance. It'd be super duper. All right, moving on now at page 5 in the bottom. Let's get to, I'm going to skip past the Telegram case here because what's more interesting is Kik, and they mentioned Library as well. Check this out. The only thing I'll mention about Telegram is they actually do distinguish between the token itself and the overall scheme. That's all. I'll just mention that. That's all you need to know. And then moving on, it reads as follows. In Kik, the court addressed an offering similar to the one in Telegram and similarly held that the sales of KIN tokens were investment contract transactions. Some dicta in Kik references the KIN token as a security, but it does so without providing any reasoning or legal support for projecting the analysis of the transaction onto the KIN token itself. Most recently, on November 7th, 2022, another court ruled that crypto asset sales violated Section 5. So that's a library case. Once again, the opinion appears to adopt the SEC's view that the token itself was a security without any legal analysis or support for the proposition. By construing the underlying crypto assets as securities, the Kik and Library courts strayed outside the bounds of all existing appellate precedent or statutory guidance. While one of those cases evaded appellate review, and the others may also, the spotlight on this case weighs strongly in favor of conducting a more rigorous analysis of this critically important distinction here. There is no need to cross the line into opining on the nature of the XRP token itself. Failure to respect that outer limit of existing precedent and statutory guidance would be an unforced error, opening any decision to potential reversal of an otherwise defensible holding for needlessly running afoul of the major questions doctrine. So there you go. That's why I'm saying, again, let Judge Torres just say, okay, not declaring what it is, but just say, well, it's clearly not a security. Just like you can say XRP is also not a dog or an elephant or a giraffe, which is the right way to say giraffe. Try that out. You can say things that it's not without declaring what it is. That's fine. I say just go ahead and do that. Here we go. And then there's this. A comprehensive review of federal appellate law confirms that Howey test cannot be used to classify crypto assets themselves as securities. A comprehensive review of federal appellate jurisprudence confirms that the Howey test does not support a determination that the object of an investment contract, here the XRP token, is a security. Thus, for a secondary transaction in a crypto asset to be a securities transaction, either one, the asset itself would need to convey a bundle of rights and obligations sufficient to be considered a security, or two, a new investment contract transaction would need to be formed based on the specific circumstances of that transaction. This conclusion is supported by a review of 253 federal appellate court decisions and 13 Supreme Court decisions, which represent all relevant appellate cases identified as applying the Howey test, either with reference to Howey or the United House Found Inc. versus Foreman. The SEC has cited no contrary authority to support treating the object sold in an investment contract transaction as a security itself. This is because no such authority exists. Boom! There you go. SEC is just making crap up. Literally, they're calling them out here. They haven't provided any case law to support their arguments because it doesn't exist. Suck it, you bitches at the SEC. You gotta love this stuff. All right, and then we've got the next part on page 10. Hold on right here. Okay, towards the bottom part of the page, right here. Oh no, I'm sorry. Actually, I wanted to go up here. No federal appellate court has found an investment contract to exist without a legal relationship to the issuer. Unlike all forms of securities recognized in our federal securities laws, XRP tokens do not bestow upon the holder any legal relationship to Ripple Labs or any other issuer, and when traded in a secondary market, they do not confer any legal relationship to an issuer from the seller to the purchaser. That distinction between XRP tokens and securities is critical. And so pause again. They're literally stating there's no case law to support what the SEC is arguing here. The token itself is separate from the scheme or offering. And then let's jump right down here. Under current law, there is simply no such thing as an issuer-independent security, a security that exists independently of any legal relationship to an identifiable entity considered its issuer. Throughout the federal securities laws, it is assumed that all securities will have an issuer, which is an identifiable person or entity against whom a security holder's rights can be exercised. When a security has been issued, many different obligations and potential liabilities are imposed on the issuer of that security, including the responsibility for filing periodic reports where the security or issuer has registered with the SEC. So let me ask you, who would be required with filing periodic reports? Would that be Ripple? And then if Ripple goes away, who's filing the reports? If somebody just becomes the biggest participant in the space, now they have to somehow, for some magical reason, file a report. This is all outside of case law. There's nothing that would indicate that's what should be done. This is complete and utter nonsense. Fantastic legal reasoning, though, is it not? Let me know what you think in the comment section below. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.